I wanted to share with you a development coming from the UK. As you may recall, the BEPS project contained a workstream on the multilateral instrument. And as part of that project, the article on permanent establishments, and in particular the one dealing with activities that are of a preparatory or auxiliary nature, were significantly expanded. At the time of the signing, the UK, along with other countries, included some reservations as to the adoption of some of these provisions. And effectively what the UK did was that they decided to reject all of the expansions relating to the preparatory and auxiliary requirement, with the exception of the so-called anti-fragmentation rule, which seeks to conclude that there still is a PE if a combination of activities by the entity or by closely related enterprises in combination constitute activities that go beyond activities that are preparatory and auxiliary. What the UK Finance Act of 2019 that became law in February of this year, February 12th, did was to include legislation required to implement the UK's position on the MLI and to introduce it into UK law. The one thing that the legislation did was to expand the definition of closely related enterprises to include situations where a UK company that is relying on the exemption is interacting with third parties. Those third party transactions still could create issues under the Article 5.4 definition of closely related enterprises. So definitely something to watch out for, and something you want to take a look at to see the extent to which some of the arrangements with the UK where you're relying on an exception are of a nature where you would want to perhaps make some changes. For more information, please check out our Global ITS Insight.